Dr. Norman, I'm making this video in order to help you to understand the process of starting a nonprofit. So far, we have produced three types of documents. One is articles of incorporation. We're going to talk about that. The other are the bylaws. And then the third set is a conflict of interest policy. Each of the articles of incorporation for each of your four corporations are the same. The only difference is the name. So the first document I want to talk about is what's known as the Articles of Incorporation. In order to receive status from the IRS as a 501c3 corporation so that you can get and solicit donations and for grants and other type of things, the state must first recognize you as a nonprofit. They recognize you by following this document here. It's called the Articles of Incorporation. And it's standardized. Most states use this format right here. I always keep up to date to make sure you found the most recent change in terms of the state requirements for the articles. And it starts with like Article 1, the name of the organization, how long the organization is going to be around, duration, purpose, what are you doing, what is it that you're doing, what do you want to do to change the world? This is where you talk about your purpose right here. Then it talks about the nature of your nonprofit. This is where you let the state know you want to be a 501c3 nonprofit, not a 501c5, a 501c9, a 501c1, but a 501c3 corporation. And this is that IRS type of language. The next thing is personal liability. This section right here is a clause that say, and you try to protect your board members. So this clause right here say that no officer or director of the corporation shall be personally liable for the debts or all obligations of the corporation, the nonprofit. So this is very important to try to protect your board members, just in case the corporation is being sued. This is the language they use that you want to use in order to make sure you protect your board members. The other thing, and this is definitely a requirement by IRS, you need to tell them what's going to happen after the organization and if the organization dissolves. What happened to all of the assets? For example, if we dissolve, let's say 50 years from now, then when you do that, if you have any assets, any money, any land, any buildings, or anything of that nature, it has to go to another nonprofit. You can't split it up with the board members, for example. And this basically articulates that language. Then this talks about prohibited distributions, what you can't do. This is a no-no. So this clause right here basically says what you can't do. This further on talks about what you can do, and it talks about the restricted activities. Normally, the first one talks about prohibited distributions, and this talks about restricted activities. And then we move to the next section that deals with prohibitive activities that you can't do. First was restricted. These are prohibitive activities that you can do by way of IRS. So what you might have gathered right now is that there is a lot of safeguards in there to make sure that people are using the money to really bring about their mission and their vision and not trying to profit by it themselves. Then this is where you begin to talk about your board of directors in this area right here. you talk about the governance. How is it controlled? And this is where you let the world know. And then your initial directors, this is where you say who they are, name and addresses. This is where your board of directors, initial board of members go. Membership. This is why you say you're not a membership organization, that the organization is controlled by the boards of the board of directors. And that board of directors is vested with the powers by way of your bylaws. And we're going to talk about your bylaws when we talk about one of the two other documents that we want to move to after we finish this. Manner of election. This is where you begin to talk about how are your people going to be elected. Like in anything in life, when you want to change something, here's the way you change it. It's called your amendments. You might amend your articles because you moved, you got a new address. You might amend your articles because you got new board members. You might amend your articles because you want to remove board members. So anything you want to do to change your corporate document, you can do it through by what's known as an amendment. And then, of course, you begin to give the address of the corporation, the corporate address as well as the mailing address. They can both be the same. The resident agent is the person that is, as you can see, is responsible for the following acceptance of obligation. This right here outlines what is the responsibility of a resident agent. Resident agent, that agent must sign off on this. The incorporator is the person that actually started the entity. Again, in this case, in both the resident agent and in the incorporator, you are that particular person. Now, let's pause for a second and look at the next document. The next set of documents is known as your bylaws. Your bylaws are basically that document that sets out the laws of the organization. That is who and what are the roles of your board members, when you meet, what time you meet, all that information related to the corporation. It starts off by putting in your introduction. Again, this is standardized. It begins with giving a definition of the board of directors. It uses this language right here. It says what the qualifications are for your board members. In Florida, unfortunately, a person has to be 18 years of age in order to serve on the board of directors. And then it lists there anything other that you might want to list related to your board of directors. For example, that all board members must commit to 20 hours of volunteer work a year. You want to make sure you got an active board of directors, and 20 hours a year is not that much. Then this is where you talk about the number of your board of directors, and you begin to say that no more than 21 and no less than 3. The least is the best, but you can go up to 21. That's chaos, I think, when you got a board of directors of 21 board of directors. Here's where you begin to talk about the terms of your board of directors, that, it's not a dictatorship. Each board of director has to be reappointed. And you begin to talk about how long they have to serve before they reappointed. Or it might be the case that they're not appointed, but you're always going to have your ongoing election of board members. This gives more information about the board members. Now, like in any organization, you're going to have a situation where people want to resign. You want to remove them from your board because they're acting a fool, or because a vacancy comes up because a person might pass away. So this gives the process of how that works. It lets you know what everything that must happen in order for the process to work. It talks about what happens when a person is removed and how you remove that person. The reason why you move that person, it gives a breakdown. Again, it gives a breakdown. It also begins to talk about that any board member shall be removed from office after he or she misses 3 consecutive regular scheduled board meetings. Again, your articles of incorporation is the laws for your organization as to what can happen and what can't happen. When there is a vacancy in the board of directors, again, this clause deals with that. It gives the process as to what happened and how that particular person, that vacancy is dealt with. This is also important because you have to have meetings and meetings by phone. So you begin to talk about some meetings you're going to have is by meetings, and some is going to be meetings by phones. This gives you the right to call special types of meetings. For example, you remember the virus when everybody couldn't meet? Well, this clause allows you to do like meetings online. So you can do an online board meeting. And I think because of the virus, a lot of people are using technology to do that when they have their board meetings. Especially if you have board members that are in different states. Here's when you begin to talk about your annual and regular special meeting. Annual meetings is like once a year. In this case right here, we had like October of each year. It can be your annual meeting. It doesn't have to be. That's changeable. And then you have special meetings. Special meeting is when you're not having your monthly meeting and something happens and the board needs to meet. This talks about what kicks in that process to call a special meeting. How much time a board member has to be given if you need to call a special meeting, and it breaks down how that happens. Okay. Then in order to conduct business, you have to have a quorum. This here is how you define what that quorum look like. And basically you're saying that if 1/3 of the board members are there, that will constitute a quorum. Now you can always change that to make it less or more, but because it's your corporation and the corporation can change that by way of the board of directors as to what a quorum is. Fees and compensation, you talk about that related to your board members. Then your roster of officer. For example, the corporation should have, and it tells you about the different positions that you're going to have. This here talks about selection and removal of officers. So just in case you need to remove an officer, not necessarily from the board, but from that position, like from the presidency or from the secretary or treasurer or any of those executive positions. This tells you what is the responsibility of the chairperson, the vice chair, the secretary, the treasurer, the president, the CEO, and how you can remove offices and vacancies. And sometimes you might have to have a waiver of notice that you have to put in. Now, right here, this should be Florida law, but the waiver of notice would say whenever any notice whatsoever is required to be given under the provision of the Florida law, and it's not going to be Georgia, of the incorporation or these bylaws, a waiver of such notice in writing signed by the persons or person entitled to notice, whether before or after the time stated in such waiver, will be deemed equivalent to giving such notice. Figure that out. Okay, that's why lawyers do this, right? You can see the language. Then you're talking about action by consent. Again, this should be Florida law and not Georgia. I'll straighten it out when I send you the final document. Appointment of committees. These are the committees that you're going to have. And there's going to be different committees. You got your executive committees. This is when you have your, this consists of the executive officers like your president, your vice president, secretary, and treasurer. And it gives what their responsibility is for the executive committee. Now, you want to make sure in terms of operations that the fiscal year for the corporation ends based on the calendar. That is from December 31st of the year. What happens with executive documents? Talk about what happens with those documents. You need to be able to show how you are being a good steward in terms of the documents, corporate documents, so people can actually see those documents. Same goes for books and records. This dictates how you need to deal with books and how you need to deal with records. Inspection of books and records, loan to management, and in this case, the office of corporation shall make no loans to its board of directors or its officer. Amendments, core ethics, and you can read this at your leisure. Authority to make statement, this is very important. If, for example, that there needs to be a conversation that needs to be made to the press, y'all should determine who that person is going to be. Sometimes a corporation will say it's the attorney, the lawyer, or it might be the CEO, but there should be a designated person that's responsible for making public statements. And then you need to talk about the limitation on statements on what that person can say. So that person just can't go out there and just say anything. Here is where you want to emphasize that the corporation doesn't have any members and is ran by the board of directors. Identification, this is important because here is where you begin to talk about how you want to make sure that your board members are protected. So if someone sues the corporation, they can only get the assets of the corporation, but not the individual assets of the board members. And then this should be your certification here. And now we're going to go to the third and final document. So let me put this on pause. IRS, Internal Revenue Services, require that you have some in-depth conflict of interest policies in order to make sure that the organization is acting on behalf of its purpose, its vision. And this basically breaks that down as to what people can do and what they can't do, and when there's a conflict of interest, and what needs to be done if there's a conflict of interest. It starts off with the purpose. It begins to talk about an interested person. And they say an interested person is any trustee, principal officer, or member of a committee with a board delegated powers who has a direct or indirect financial interest in the particular issue before the board of directors. It becomes a conflict of interest if someone will get a financial gain or anything related to finance interest in it. And this breaks it down. Further, it breaks down on what a financial interest is. So people are clear what they cannot do and what is considered to be a financial interest. It then goes on to talk about the duty to disclose. It goes down to determine whether a conflict of interest exists. And this is what you can do to determine if it does. And it talks about procedures to address the conflict of interest. As you can see, they're very detailed. Very detailed. And then your next article deals with records of proceedings, how you're going to document it. Compensation committees, whatever compensation committee might need to come into play. So this is what gives that committee, bring that committee into power and what it has the power to do. Now, it further goes on to talk about each trustee, board member, officer, etc. in terms of an annual statement, what you have to provide. Periodic reviews, it talks about that. That's important to make sure things are being done like they're supposed to be and you're not jeopardizing your status. And then finally, every board member should sign off on this. So now these are all the 3 documents that you have. I'm going to send you the final draft of the articles of incorporation for each of your individual organization, as along with the cover page. Let's look at what the cover page is going to look like. Let's pause for 1 second. This is going to be the cover sheet for each of the nonprofits that you submit to the state. Keep in mind, you're going to be submitting 4 different cover letters. Let me see if I can enlarge this. Yeah. So the cover letter, and I'm going to type it in and send it to you, is going to have the name of the corporation. I've checked this box right here because the filing fee is $70. Now you can also, if you choose to, ask for the filing fee and a certificate of status. That means you get the articles of incorporation and then you get a certificate saying you're in good standing. But first year, you can do it if you want to. But the first year, I tell folks, if you ain't got no money, unless you think you got money coming in, do the $78.75. The first thing you're going to ask is for you to type in who it's coming from. Your name, your address. I'm going to type in the zip code, the city and state, and the email. Now, when I send you this right here, you're going to be able to go in and click this, like this, if you don't want that. But for right now, let's assume that you just want to file the application. Keep in mind, you also can file and ask for a certificate of status as well, and that's 7875. Now, once the article has been entered into the state, and the state stamps it with its approval by way of a letter that they're going to send you that you know you've been approved, and they're going to have a stamp. It's going to be approved. It's going to give the date of that approval. The next step then is to file for the tax status by way of IRS. And we do this online. We can do this online. And what happened is that I will send you, when we get to that point, a link on how to go on and initially start the application so that I can complete it. For example, you'll go on, you'll put your name down, put your address down and the name of the organization, and then you'll send that link back to me for me to go in and complete the application for each of the separate nonprofits, and then I'll send them back to you for you to actually file with the state. Now, keep in mind, it's going to be $275 per corporation. Just like it's going to be $70 per corporation. So far you have made a payment of $375. I appreciate that. And that $375 was half of the total based on 3 nonprofits. But as you know, you added a 4th nonprofit. So I'm gonna just add an additional 100, and then that total balance is gonna be $475. Now, why is this important that you do your articles and everything this way? Because when funders look at your articles and your bylaws and stuff like that, that's how they fund organizations. And a lot of times when people are putting together their initial documents, they don't have the critical things that what funders look for. That's why it's good to have a person that's familiar with nonprofits to put together the initial paperwork. As a matter of fact, I have lawyers that come to me and ask me to put together their document for the articles of incorporation, because they might specialize like in criminal law, or they might specialize like in civil law, but they don't really have that grasp of like with nonprofit. So yeah, even the experts come to me, and I look forward to not only working with you with getting your nonprofit started, but we also work with you to get it operational and the type of training that you're going to need in order to attract funders. So hopefully you got this. Before we get an opportunity to see each other, so you can go over it, and then I will send you the documents. And thank you again for giving me your business and allowing me to help you to bring your dream to bring your dream into play. Thanks again. Looking forward to a follow-up.